Hey everybody, it's July 25th and time for another weekly quick update. If you're in the Fraser Valley, you may already have heard about Fraser Health's initiative to force euthanasia on all hospice and palliative care facilities in the valley. The Langley ARPA and Fraser Valley East ARPA groups have been watching this issue closely and have decided to push back. They've created a radio ad and social media campaign. Here's the ad now.
When someone you love is dying, you'll be embarking on a heart-wrenching and difficult journey. Hospice palliative care is designed to provide support to your loved ones during the final phase of natural life so they can live each day as pain-free as possible. BC's Fraser Health wants to change all that. Fraser Health is mandating that euthanasia be available in hospice settings. Help by telling Fraser Health no. For more information on how you can help stop this from happening, please go today to saveourhospice.com and send an email to Fraser Health. Help keep hospices safe.
They're asking for your help to support this and help them raise the $10,000 for their campaign. Contact ARPA Fraser Valley East at gmail.com for more. Next up, I've got one of ARPA's lawyers, John Sikkema, with me, and we're going to talk about the recent court case that may affect the way charities can be involved in political action. Hey, John.
Hey Colin, this is a big decision for charities and maybe even for organizations that want to become charities and enjoy the tax benefits.
So what's this all about?
A registered charity called Canada Without Poverty got into trouble with the Canada Revenue Agency because virtually all of its activities involved advocating for changes in government policy to help relieve poverty. In Canadian law, a charity may not engage in political activities unless those are closely related to its charitable purpose, such as relieving poverty or advancing religion. Even then, a charity may only devote a maximum of 10% of its resources towards those activities. Canada Without Poverty was in trouble because it went way over this 10% threshold, but they argued in court that the 10% rule violated freedom of expression, and they won. The judge said that because their purpose was charitable, namely poverty relief, they should be completely free to pursue that purpose through nonpartisan advocacy. He also said that the 10% limit is pointless and no longer applies.
Does this affect all charities across the whole country?
The judge didn't just change the way the rule applied for the Canada Without Poverty organization. The judge said the rule itself is void, effective immediately. We don't know yet if the ruling will stand though. We'll have to see if the government appeals. But if the ruling does stand, it means that charities can do nonpartisan political advocacy provided it is closely connected with their charitable purpose.
Great, thanks so much. Well, back to Ontario, and a number of Christian physicians groups have issued a lawsuit against the College of Physicians and Surgeons over the lack of conscience protection for doctors. Basically, it's like someone comes to you asking for help in dying and you have to write an effective referral or basically send them to the next doctor saying, please take care of this medical assistance in dying for me and sign it. ARPA's lawyers have just finished applying to intervene in this case and we await that decision. But either way, we're going to keep a close eye on this one in the coming weeks for sure. Well, we're right in the middle of the dog days of summer, and John has been accepted into a Master's of Law program in Atlanta, and he'll be studying there for the next 9 months or so, starting in August. A number of the staff, including myself, will be gone next week, so talk to you again in early August.